It was, yeah.
Thank you.
Okay, we're live on YouTube now. You should be able to see somebody's talking. I think some kind of court administrator. Oh, Kim. It's the chief judge for the 12th Judicial District who's talking.
Wow. Washington.
Yep. Mm-hmm. Mm-hmm.
So as you make
Is it not loud enough, or is it?
plays in our state government and what it actually does. The Supreme Court of Kansas appears to be and administers the district, 31 district courts for the state of Kansas. And the Supreme Court also handles all of the attorney issues in the state. Many of you may have never had any dealing with the court system, or if you've never, most of you have not.
What's the? Is that the?
Give you a brief description of what happens in the court system and how it leads up to where we are this evening. I believe that most people, when they think of the court system, automatically think about criminal cases. And that's true, we handle felony and misdemeanor cases, but there are thousands of cases filed each year in Kansas that cover all types of issues. Obviously, the criminal cases, but there are contract disputes, personal injury cases, property damage. There are banking cases and foreclosures, adoptions, evictions. There are trust disputes and probate matters, name changes, eminent domain. There are divorces, child support issues, custody, parenting time, fish and game issues, traffic, and child of need of care. Just about every type of financial or personal matter that can arise in your life can come before the court. And across the state of Kansas, all of these types of cases, regardless of the type, they all have a common element. They always begin at the county level. Depending upon the type of case that is filed, some are assigned to a magistrate judge and some are assigned to the district judge. Many individuals can and do file a case on their own. Sometimes people hire an attorney to represent them, and at other times it might be the county attorney or a district attorney that's the prosecutor. And in those cases where an individual is unable to afford an attorney for their criminal defense, then the state appoints an attorney to represent them so that their rights and privileges are protected throughout the criminal case. In many situations, the judge decides the case based on the law and the facts of a particular matter. But there are other situations when, like in a criminal case or in a civil dispute, when the parties may choose to have a jury trial. And at least on television, that's the most common type of case that we see. So what happens when there's a jury trial is the attorneys present witnesses, the individuals who tell the story of what has happened, and they might present exhibits. The judge provides law through instructions to the jury. The jury listens to everything, takes those instructions of the law, applies them to the facts, and then decides the case. So if it's a criminal matter, they decide if someone is guilty or innocent. And if it's a civil matter, they may decide whether someone is negligent, whether there's been a breach of a contract, if someone's been damaged, and if so, what the damages are. And what I've just described to you all occurs right here at the county level in the 12th Judicial District. In our district, cases range from multi-million-dollar contract disputes to division of mom and dad's wedding photo after they've passed away, or it might be a $1,000 unpaid rent dispute. It varies greatly. What happens when someone's not happy with the outcome of the case? They may think there's been a mistake, the jury just didn't get it right, the judge didn't apply the law correctly. So in those cases, state law and court rules govern when and how cases may be appealed. And they're either appealed to the Kansas Court of Appeals or to the Kansas Supreme Court. In most situations, the appeal begins at the Court of Appeals. And there are a number of Court of Appeal judges, but only 3 at a time hear a case. And they don't get to hear the testimony and listen to the witnesses. They read a transcript of what occurred, and they read the briefs that are written by the attorneys and the arguments that are being disputed about what went wrong in the case. The Court of Appeals will then make a decision whether there was a mistake, whether everything was just right, or sometimes they might split it. So they affirm when they say, trial court, you did it right. Whatever they're arguing about, you did it right. You're affirmed. Sometimes they say, well, this part was right, this part was wrong, and you need to go back and do part of it again. Or they may say, that was so screwed up, that case is reversed and it's done. Now, what happens when an individual or a business doesn't agree with the decision of the Court of Appeals? Then they can ask the Kansas Supreme Court to consider their case. And generally, the Supreme Court limits its cases to those that involve constitutional issues, a case of great significance across the state, and in some cases, law dictates that they must hear it, such as in a death penalty case or higher level felony matters. And the process before the Supreme Court is very similar to what I just described to you for the Court of Appeals. They will read the transcript. They don't get to hear the witnesses, and they read the briefs, and they listen to the oral arguments. And that's the point we are at tonight. You will have the opportunity this evening to watch and listen to oral arguments. And there will be 2 types of cases presented to you. There's a civil case, And in that case, Kathy Stroud has sued her deceased husband's insurance agent and insurance company. She claims that the agent or the company was negligent and breached its duty when a life insurance policy changed from term to whole life. And at the trial level, the district court dismissed the case before it even was tried. Well, Kathy didn't agree with that decision, and she appealed the decision to the Kansas Court of Appeals. The Court of Appeals agreed with the district court and affirmed its decision. And Kathy then filed a petition for review, asking the Kansas Supreme Court if they would hear her case. And they granted that request. And tonight they will hear the oral arguments by the attorneys on both sides. The second case presented tonight will be a criminal matter. It is an appeal, and criminal cases they involve the state of Kansas charging an individual with a crime or several crimes. The local county attorney, or sometimes the Attorney General's office, will represent the state of Kansas. In the case before you tonight, it is an attorney from the Attorney General's office who will be representing the state. And this scenario is this. It's similar to many that come up in our district. Law enforcement made a traffic stop. And as the law enforcement officer approached the vehicle and talked to the driver, he thought he could smell an odor. This led to a search of Frank Crudo's vehicle and trailer camper. Drugs were found. Mr. Crudo was charged with crimes, and he had a jury trial. The jury found him guilty, and he was sentenced. Mr. Crudo was not happy with the situation as it occurred, and he argued there were mistakes. And one of the primary arguments in this case has to do with the Fourth Amendment. We all have a right to privacy. We have a right to be free from unreasonable searches and seizures. And he had a camper behind his vehicle. And our homes are sacred. The privacy we have in our homes is a sacred right. So did that law enforcement officer have the right to search his home? That is one of the issues that will be presented in the case and argued. There was also an issue about the expert witness who testified. Mr. Crudo believed the expert did not have the qualifications to present the testimony he did. And also that several of the instructions provided by the judge lessened the burden of proof from something lower than beyond a reasonable doubt. And so those are the errors that what he believes are the errors and what will be argued. After this evening, the court has already read the briefs submitted by the attorneys. And after this evening, the justices will conference the case. And when they conference a case, they meet, they discuss the issues of law, they conduct additional research, and then they reach a decision. Sometimes it's a unanimous decision, and sometimes it's a divided decision. But eventually there is a written decision that says this is what the rule of law is, and this is why, this is the reasoning for our ruling, and here's the decision. So I hope that I have provided to you, I know that was really long-winded, but that was my short synopsis of how a case works through the court system anywhere in the state of Kansas. So once again, I want to thank you. I want to thank you for coming out tonight and showing your interest in this event. And I also want to thank the Kansas Supreme Court and the individual justices for taking their time to come to our community and to share with us an important aspect of their job. I believe the court is ready to begin, so thank you.
The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Thank you, retired Chief Judge Tuggle. More about our bailiff. We appreciate his participation tonight. Good evening. I am Chief Justice Marla Lukert, and it's my pleasure to welcome you to this special session of the Kansas Supreme Court. We're excited to be in Concordia today and to provide you this opportunity to watch our court and to meet the justices during the reception that will follow our oral arguments. In an effort to make the courts more accessible to Kansans, we have turned to the Beach Boys to provide our Supreme Court on the Road theme song of Round, Round, We Get Around. A couple of times a year, we leave Topeka and visit a Kansas community to show Kansans how our court works. All our hearings are public, but few Kansans take time from work, school, or other demands in their lives to come to Topeka and to watch a hearing. And while you can watch any of our hearings on our YouTube channel, that doesn't provide the opportunity for you to meet us and to ask us questions, as we'll do after the session. So here we are, getting around. We've spent the day visiting area schools with local judges, and we will visit more schools tomorrow. We appreciate those schools who have allowed us to come into their buildings and to visit with their students. These schools or schools that have been with us today include Cloud County Community College, Concordia High School, Smith Center High School, Rock Hills Junior Senior High in Mankato, Minneapolis, Tescott, Glasgow, Bennington, Miltonville, Lincoln, Clay Center, and Beloit. We estimate that we've reached, or by tomorrow, end of tomorrow, we'll have reached over 1,100 students over the 2 days. We also met with area attorneys earlier today, and we welcome any of the members of the bar who are joining us this evening. So this evening, as I said, you have a chance to firsthand learn who we are, what we do, and how we do it. We're delighted that you have taken the time to learn more about how Kansas courts work. You will hear and see arguments in 2 actual cases that are from our docket. As you now know from Chief Judge Cudney's introduction, which we appreciate, public Supreme Court proceedings are often referred to as oral arguments. Attorneys will present legal issues to support their clients' positions. The attorney for one party will argue first, the other side will respond, and then that first attorney will have a chance to have the last word or the rebuttal. Justices will ask the attorneys questions throughout the arguments to learn why the attorneys believe the law supports their clients' positions. This interaction helps us meet our duty to enforce the rule of law and make the decisions the law requires. The parties have presented us written briefs, cited the laws they believe support their position. This might be the United States Constitution, the Kansas Constitution, statutes passed by the Kansas legislature, or court decisions. The law will form the basis for our decisions in these appeals. We don't evaluate whether the law is good policy. That is the job of the legislature. Our obligation is to set aside our personal beliefs, politics, special interests, and even public opinion. That means, for example, that we are not going to take a opinion poll at the close of today's arguments to ask you what you think or how you think these cases should be decided. We have to remove ourselves from all of those influences because our job is to maintain fair and impartial courts for all Kansans. As Thomas Jefferson said 200 years ago, the most sacred of the duties of government is to do equal and impartial justice to all its citizens. We hope you leave this evening with a better understanding of the contributions of lawyers and judges in furthering the rule of law and understand better the role of fair and impartial courts. I would now like to take a moment to introduce my colleagues who come from all over the state. I will first mention that I grew up in the far northwest corner of the state in Goodland. Next in seniority is Eric Rosen, who hails from Topeka. Then in seniority is Dan Biles, who grew up in El Dorado. Caleb Stiegel from Lawrence. Evelyn Wilson from Smith Center. KJ Wall from Scott City, and Melissa Taylor, also from Lawrence. We're getting closer to calling our docket, but before we do, I do need to take a minute or two to express some gratitude to several people who made this evening and these 2 days successful. I will begin with the judges of the 12th Judicial District. Kansas is divided into 31 judicial districts, and a judge resides in all 105 counties. The 12th is one of our largest districts geographically. It consists of Cloud, Jewel, Lincoln, Mitchell, Republic, and Washington counties. The judges from these counties have helped with the planning and the school visits. Would the local judges please stand? I think you're spread out a little bit, mostly down here, but we've got Judge Cudney behind. So we have Chief Judge Kim Cudney, who you met earlier, judges Jason Cohorst, Jennifer O'Hare, Kevin Phillips, Guy Steyer, Regine Thompson, and Deborah Wright, and Kevin Phillips. Did I miss anybody? I catch everybody. Thank you. We thank them for them. I'd also do a special call out to the Chief CSO, Wanda Backstrom from Cloud County, and the Chief Clerk, Christy Benishek. We also thank the clerks of each of the various counties as well. And I also want to thank my staff, our staff of the Supreme Court, the clerk of the Kansas Appellate Court and his staff, the staff of the Office of Judicial Administration who oversees the logistics of setting up these dockets. As you can imagine, it takes quite an effort to get 7 of us on the same page, the same place at the same time, and in the various places we go. And another group that I would like to do a shout out to, you probably saw that there was quite a bit of law enforcement presence. We usually ask for some help in securing the building and also just helping with traffic and directions for people. And your local law enforcement officers responded with an overwhelming level of assistance. So the Concordia Police Department, the Cloud County Sheriff's Department, also the Kansas Department of Wildlife and Parks, which is a new group for us to have involved, Cloud County Community College Security, and the Kansas Highway Patrol. Thank you to all of those. And now I'll circle back and say another thank you to where I started, and that would be our thank you to our honorary bailiff tonight, retired Chief Judge Tom Tuggle. We are excited to have Judge Tuggle return in this form. He served many years as with some of us while we were judges as well. So Chief Judge Tuggle is one of those people who never stops giving back. In 2006, he said he was retiring, but we were able to call on his service as an assigned judge from then until December of 2011, another several years after he had supposedly retired. He began his service as a judge on July 29th, 1989, and then he served for 17 years here locally as a judge. He, like Chief Judge Cudney, served as the chief judge in charge of the operation of the courts in the 12th Judicial District. I had the fortune of serving with him on the Kansas District Judges Association Board. And that included a period when I was lucky enough to be on the board when he served as president. From that experience, I know that he has contributed enormously and in countless ways to Concordia and to the entire 12th Judicial District, and frankly, to all of Kansas. And I know firsthand of his outstanding character and his high integrity. He was highly respected as a judge. He is highly respected as a judge and as a leader in our profession. We are honored to have such an outstanding former colleague and friend serve as our bailiff this evening with us. So thank you. And now we'll get to the business that brought us all here tonight. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call this evening's docket.
Thank you, Your Honor, and may it please the court. The first case on the 6:30 PM docket for Tuesday, April 11th, 2023 is appeal number 124348. Kathy L. Stroud versus Ozark National Life Insurance Company and Stephen I. Gwynn, Sedgwick County, briefs both sides. Council will approach and enter your appearance.
Good evening. I'm Roger Wilson, attorney for Kathy Stroud, the appellant, present and ready for argument, and I'd like to reserve 2 minutes for rebuttal.
2 minutes is granted. Thank you.
Christina Hansen, appearing on behalf of Ozark Life Insurance, and Stephen Gwynn, ready and present for our argument.
May it please the court. My name is William Hanna, and I'm also here on behalf of the defendants, Ozark National Life Insurance Company and Stephen Gwynn, and we are present and ready for oral argument.
The second case on the docket is appeal number 123559. State of Kansas versus Frank Raymond Crudo, Geary County, briefs both sides. Council will approach.
May it please the court, Peter Meharry for Frank Crudo, present and ready for argument. If I could reserve 3 minutes of my time for your honor.
3
Rebuttal,
minutes.
Your honor.
I'm sorry, 3 or 5?
3 years.
3. 3 minutes is granted. Thank you, Mr. Meharry.
May it please the court, Tony Cruz on behalf of the state of Kansas, present and ready for argument.
Thank you, Mr. Cruz.
Thank you, counsel. Your Honor, that concludes the docket for April 11th, 2023.
Thank you, Mr. Shima. As council settles, I'll just add a couple of additional explanations. First, there will be no break between the cases. So if you need to leave as the attorneys transition from one case to another, please do so quietly. Second, I want to explain that the justices are familiar with the facts of the case and the parties' arguments. We may at times take notes. We may at times use our computers to consult our own notes that we have taken from reading the briefs and the legal authorities that those parties have cited. We may be checking a case or doing something else. We do that to assist in our understanding of the arguments. Please understand that when we are doing that, we are actively listening to the arguments and actually helping us to assimilate the issues that the parties are presenting to us. So with that, I will now call 123348. Mr. Wilson. And counsel, for purposes of the recording, when you get to the podium, would you please state your appearances again as you begin your argument?
Thank you once again. My name is Roger Wilson, and I'm here on behalf of the plaintiff appellant, Kathy Stroud, and I want to thank the court for agreeing to hear this case this evening. Plaintiff appeals from a decision by the Court of Appeals which upheld the district court granting defendant summary judgment motion in this case. The courts have had before it, as you do this evening, a set of uncontroverted facts on which the decision must be based. I think there are some 40 uncontroverted facts, but boiled down briefly, those facts tell us that defendant Gwynn initiated contact with the Strouds, claiming he needed to talk to them about the $60,000 term life insurance policy on Mr. Stroud's life. No, he didn't. They met the next day at the Stroud home, and defendant Gwynn told the Strouds they needed to look at converting the term policy to a permanent status. No, they didn't. The annual premium on the term policy was $400.80 a year, and it was not scheduled to increase for another 3 years. Defendant Gwynn knew this, but defendant Gwynn led the Strouds to believe, and these are all uncontroverted facts, that the $400.80 premium could drastically increase when the Strouds were in Houston, Texas, for Mr. Stroud's imminent life and death surgery, which could be at any time. Defendant Gwynn knew about this surgery. The Strouds were concerned that if those premiums drastically increased when they were in Houston, Texas, they might not have enough money in their bank account from which the premiums were being withdrawn to pay those premiums, and they would lose their insurance coverage. So when defendant Gwynn left the Stroud home that day, the Strouds had converted the $60,000 term policy with a $400.80 annual premium to a $30,000 whole policy with a $1,538 annual premium. After the meeting on May 6, 2019, and after his surgery, Mr. Stroud passed away 3.5 months later. And those premiums, those $400 premiums, had another 2.5 years before they would increase. We have brought this case on the theories of negligent misrepresentation and breach of fiduciary duty. Both as those theories apply to the plaintiff, and as both of those theories apply to Mr. Stroud, for which the plaintiff claims a right to sue. Now, this case has been extremely and extensively briefed. The plaintiff relies on those briefs and those arguments in those briefs. But tonight, I would like to address 2 aspects of this case that I'd like the court to take away with it from this argument. We're asking the court to apply the law of negligent misrepresentation and the law of fiduciary relationships insofar as the plaintiff is concerned to the uncontroverted facts of this case. In that regard, we contend that the uncontroverted facts of this case show that this was as much of a business transaction for the plaintiff as it was for her husband, the insured.
Counsel, can I ask you a question about the duty of what you're alleging, that it's a fiduciary duty, but historically under our precedent, how have Kansas courts defined the legal duty an insurance agent or a broker owes to a potential customer?
Well, I think that depends on the facts of the case. And I think it's
Well,
very,
I think legal duty would be a question of law. What is that duty? How have we articulated that duty?
you've articulated it in PIC 4th edition 127.43 as one who in the course of his business, and that would be the insurance agent, Mr. Gwynn, supplies false information for the guidance of another person in such other person's business transactions. And then there are 3 subcategories that the person who is receiving this information has to meet. The second one states the person who relies upon the information which would be my client, is one of a group of, is the person or one of a group of persons for whose benefit and guidance the information is supplied. And thirdly, the damages are suffered in a transaction that the person supplying the information intended to influence. So what I'm saying is, under the facts of this case, Defendant Gwynn knew that he was providing information not only for Mr. Alan Stroud, but he was also providing information for the plaintiff in this case, and he fully intended to influence her.
What is the false information that you're relying on that was communicated to the Strouds?
The false.
It might not have been direct information, but was it false?
Absolutely. There is an uncontroverted fact that he led them to believe that that $400.80 premium could increase at any time. It could increase while they were in Houston, Texas, which could be at any time. And that simply wasn't the case, and Defendant Gwynn knew it. We believe all of these requirements for the creation of a fiduciary relationship were met between the plaintiff and Defendant Gwynn. For this reason, a decision to reduce, I'm going to read this because I put it together and it states it better than I could stand up here and verbalize it, but a decision to reduce life insurance proceeds of which the plaintiff was the beneficiary by $30,000 was a critical decision in which the plaintiff was an integral part of the decision-making process under the uncontroverted facts and circumstances of this case. She was not a mere bystander in this transaction. It was as much of a business transaction for her as it was for her husband. She had to be influenced to convert the policies as much, if not more, than her husband. Defendant Gwynn was speaking to both of them, and the uncontroverted facts, as you read through them, will clear that up. Three in particular, please keep in mind that Mr. Alan Stroud had had a stroke in January of 2019, and uncontroverted fact, his faculties weren't complete. He couldn't read more than one sentence. He couldn't deal with numbers whatsoever. More importantly, it's uncontroverted that plaintiff and her husband would always talk about anything they were going to buy, including life insurance. Neither was a primary decision maker over the other. It was a combination. They made financial decisions together, including the decision to convert this term policy.
Can you help me figure out how it is that the assistance Kathy was providing to her husband helps with her own personal cause of action against Ozark?
I never thought of it in terms of her assisting her husband, but they discussed this together, and it was a joint decision. It was his decision and it was her decision, and neither party had the final decision-making ability. They had to come together to do this, and that's what they did.
How do we overcome the fact that the only signature that was needed, was required to change the policy, was the husband's?
Well, it was his policy, so he's the one that had to sign it. I don't think that detracts or takes away from the fact that before he signed it, he needed his wife's consent. They needed to agree together.
Was there any dispute in material fact about whether he was capable mentally of signing a contract?
That really hasn't come up, no. But I do think it's somewhat material that his abilities were limited. Even if his abilities weren't limited and he was fully, with full capabilities, I don't think it would change our argument that he and his wife both had to make the decision to convert.
I was kind of interested in, when I first read these facts about what prompted Mr. Gwynn to initiate phone call to go talk about the policy. requirements. And there's a reference in his deposition of him just having a practice of checking on policyholders who are within 5 years of their getting to their term. And I think he said that the policies he at least works with, if not all the policies, are 20-year term policies. And so is that true? I mean, is there any reason to doubt that he simply has a practice of checking on all the policyholders as they come
That-
out of the 5-year thing? Is that controverted at all, or
No, he said that's what he was doing. Keep in mind that defendant Gwynn was not the insurance agent for the Strouds. The person who sold the term policy to the Strouds in 2002 was another insurance agent who hadn't left them. And this other insurance agent has said that it's a company policy to send out a letter a year before the premiums are to increase, to remind the policyholder that the premiums are going up. So defendant Gwynn took it upon himself to go through files and find these people who had term life insurance policies to go talk to them. And when he said he needed to talk to them about the policy and they needed to think about converting this policy, that just wasn't the fact, particularly in light of the circumstances in which the Strouds were at the time, with Mr. Stroud facing life and death surgery, imminent life and death surgery.
Counsel,
He wouldn't necessarily have known that when he initiated the call to make contact, right? I mean, those were the circumstances, and maybe he should have known the circumstances or found them out, but I'm still just, the very first thing I wanted to figure out in my own mind is, why did this guy pick up the phone? In order
This
to
guy
call
being Mr. Gwynn.
Gwynn, when
Yeah. It was,
when the other agent is, the one with the
Yeah, well,
relationship.
he did. And he was told in that telephone conversation with Mrs. Stroud about this surgery. So he knew about the surgery before he went to the house.
counsel, is the rule you're essentially asking for in this case that agents owe fiduciary duties to beneficiaries of policies?
Not as a blanket determination.
What's the difference then? What sets this case apart from a blanket rule?
Well, I believe it's because Mr. Gwynn initiated this contact. A lot of the cases we have seen in the briefing have to do with a continuing duty to advise and all that, but he set this up.
Well, why does that matter? Because I'm specifically asking about the fiduciary duty owed to the beneficiary.
Because he set it up saying that there was a need to talk about insurance. So Kathy Stroud said, well, we're having this surgery, so if there's a need to talk about insurance, we better do that. And so he set up the situation where he was coming to them to talk about an existing policy. He wasn't trying to sell them a policy, but talk about an existing policy.
Is that a legally workable rule? In other words, I'm just thinking about future cases. How would we adopt a rule that would be workable in future cases?
We're talking about, well, negligent misrepresentation. We're also talking about fiduciary duty, which,
That's what I'm specifically interested in.
yes, which there is, you've got to look, the law says we've got to look at the facts of every case. And there are no specific rules. You have to look at the facts to see if those facts lend themselves to a fiduciary relationship. And here, defendant Gwynn came to the Strouds and said, trust me, we need to talk about this. The uncontroverted facts say that they relied upon him. He knew they were relying upon him.
It just strikes me that you're setting up a potential conflict, or perhaps a conflict with respect to every single policy if the agent owes fiduciary obligations to both the policyholder and the beneficiary.
If there is a possibility of a conflict there, it is not present in this case. And if we look at the facts of every case, in this particular case, Kathy Gwynn was the beneficiary of the $60,000 policy. She was beneficiary of the $30,000 policy. Alan Stroud never changed that beneficiary designation. And their interests were aligned. There was no conflict. Defendant Gwynn could have a fiduciary relationship with Mr. Stroud. He could have a fiduciary relationship with Mrs. Stroud, and the two would not conflict. They were going down the same road.
Is it fair to say then, to summarize your argument, as I'm hearing it at least, that whether an individual, in this case, an agent, was acting as a fiduciary is a question of fact that depends upon all the circumstances and the evidence that supports it. And then if that individual is acting as a fiduciary, the legal duty then becomes a question of law. And essentially, as I understand it, the legal duty is to act with good faith and loyalty towards the individual that you're acting as a fiduciary on behalf. Is that a fair summary
I
of
think that's-
separating the factual question from the legal question here?
Yes, I think so.
And likewise, on the establishment of the business relationship, is that portion a factual relationship? And then would you be able to apply current law, or would we have to extend the law to allow that to apply to a third party, to a contract where there isn't a contract involved, in this case with the life policy?
I don't think this court has to worry about establishing law. I think the decision in this case can be made based on the facts of this case. And because of A, B, C, D, and E, here's what we end up with.
What if a hypothetical person who's similar to the deceased in this case just has a really good friend? And that person just likes to get the advice of the really good friend. And the insurance agent goes and tries to convince the really good friend, who's not a beneficiary or anything. I mean, is there a fiduciary relationship there?
I'm not sure I understand the question, but
I'm trying to probe the limits of the.
Yeah, I
of the
understand.
Sort of facts and circumstances that can create a
My-
fiduciary relationship.
My knee-jerk reaction to that question is, I doubt it.
That's kind of my,
Yeah.
obviously, the thrust behind the question. So is what distinguishes the facts that are before us from my hypothetical. I can think of a couple. One, that your client was beneficiary, and two, the marital relationship essentially. Is that getting closer to where
Yeah.
you want to see a fiduciary relationship established?
I just think we need to, the reason I appreciate so much you all hearing this case is, I don't think any court has looked at these uncontroverted facts, really looked at them and applied them to the law of fiduciary relationship. Because I think we touch all the bases. I really do. Now, the clock says I'm out of time. I've got more to say, we could, but.
Are there other questions? Okay, thank you, Mr. Wilson.
All right.
May it please the court. This court should affirm the ruling of the Court of Appeals because both the Court of Appeals and the District Court correctly ruled first that the plaintiff is not the real party in interest to bring the claims that survived her husband. Second, there's no fiduciary duty that exists between the defendants and the plaintiff in this case. And third, because the defendants are entitled to summary judgment on plaintiff's claims for negligent misrepresentation. So it's for those reasons that the ruling of the Court of Appeals should be affirmed. In addressing first the issue about the real party in interest, that issue takes out the issues about any potential claims that any duties would be owed to Mr. Stroud that Mrs. Stroud attempts to raise in this case. Because Kansas statute annotated 6271A1, which is cited in the briefs, says that an action must be prosecuted in the name of the real party in interest. And that gets to the fact that any duty at all that could have been owed by Mr. Gwynn or Ozark in this case would be owed, if to anyone, to Mr. Stroud. not Mrs. Stroud, who's the plaintiff in this case. Plaintiff attempts to assert tort claims, the breach of fiduciary duty and the negligent misrepresentation claim, based on alleged duties owed by the defendants to her husband, not to herself. And it's the husband who's the owner of the policy to which she was merely the beneficiary. So that's the specific issue that's among the narrowest in this case. And I believe the court can address this appeal on the narrowest grounds possible by simply addressing the fact that the plaintiff is not the real party in interest to allege claims that would be properly owed if by anyone by her husband.
Typically, sorry,
Go ahead.
typically there can be at least a relatively easy process of substituting the real party in interest when there's a real party in interest problem.
Correct.
Why can't that just happen
Correct.
here?
And-
Why
and that-
didn't it happen?
And that has never been done in this case, Your Honor. Right from the jump, the defendants raised the fact that there was not a real party in interest on our affirmative defense in our answer. Very first pleading we made. The plaintiff sent an interrogatory to the defendants asking us to explain the factual basis behind the real party in interest defense. We explained in that interrogatory. We also then filed a motion for summary judgment citing that basis. In other words, that defense has been front and center from the very beginning of this case. There's never been administration of an estate, as far as I know, that's ever been opened on behalf of Mr. Stroud. So that may be answer your question. But we have raised that issue from the very beginning because it's important to keep in mind that it's Mr. Stroud, not Mrs. Stroud, that's the owner of the policy. It's Mr. Stroud that had the obligation to pay the premium. It's Mr. Stroud that had the right to cancel the policy if he chose to, not Mrs. Stroud. He could also change who the beneficiary was. He could change it to make it a family member or someone else other than Mrs. Stroud. That's why he's the real party in interest in this case.
But what about
Go ahead, you go.
what about the $30,000?
Right, the $30,000 has been paid to Mrs. Stroud. Okay.
The other
for-
$30,000.
Okay,
Between the 60 for the term and the 30 for the whole life.
Sure,
Because she was the beneficiary. So if it's
Right.
in his name, his damages would be the lost premiums.
right. Or, well, I believe this court had addressed that similar issue in the Corey case from 1950, and that's cited in the briefing. And in that case, that's the one where the son took the flight lessons from the flight school. The flight school allegedly promised to take out life insurance for him and didn't do so. The parents then sued for fraud, a very similar case to this. And
But flight companies don't generally provide insurance. And that was
Right.
a critical point in the court
Right.
case.
But the fact of the same was they were going on the same basic premise of fraud, just like the plaintiff makes a claim for negligent misrepresentation. And in the Corey case, this court ruled that any cause of action for fraud, or in this case, negligent misrepresentation or breach of fiduciary duty, must be maintained by the personal representative. So the personal representative then can make the claim, whether that personal representative would be Mrs. Stroud or whoever would be the administrator or executor of the estate, and make the claim on behalf of the estate to be able to say that they had been fraudulently entered into or not entered into the contract. And it's the similar ruling that the Court of Appeals made in the Patterson case just a few years ago, which is also cited in the briefing.
But doesn't Kathy have a much stronger argument here that she ought to be able to expect insurance companies to get the right insurance?
Well, the fact remains is they did get the right insurance. There's no claim in this case that Mr. Stroud asked for a different policy and Ozark gave them something else. Mr. Stroud got exactly what he ordered. This is not a situation like in some of the cases where the plaintiff alleges I asked for a policy for $500,000 and you signed me up for 30. This is a case where Mr. Gwynn followed the instructions that he was given, which makes it different from those other cases. He was given exactly what he bargained for and asked for
Well, I
and
think,
made that change.
first of all, I think he asked for that. I think, anyway, I mean, I don't want to speak for the plaintiff, is saying that the negligent misrepresentation was, you need to do this because your premium is going to triple, and it could happen while you're in Texas when you can't even control that. So those are uncontroverted facts.
Yeah, there are 6 alleged misrepresentations that the plaintiff alleged, both in answer to an interrogatory and in the pretrial order. 4 of those 6 alleged misrepresentations were statements that were actually made by the plaintiff or Mrs. Stroud, not Mr. Gwynn. In terms of the only 2 that were made by Mr. Gwynn would have been the fact that the premium was going to increase, and it was going to increase, and it was going to increase significantly. It was also not going to increase for 3 years later after the fact, which again was known by the Strouds because they had the policy, the term life policy that told them that. And further, as is indicated in the briefing, there's the recorded telephone conversation between Ozark and Mrs. Stroud, in which Ozark actually tells Mrs. Stroud in February of 2018 exactly when her husband's policy is going to expire, what the premium is, and what the new premium would be.
But isn't that a question of fact as to whether or not it's a lie or a misrepresentation, or if Mr. Gwynn acted inappropriately?
Well, I think at some point the plaintiff has the burden to show what was the exact fact that was misrepresented. And that also has to assume a duty that was given to Mrs. Stroud as opposed to Mr. Stroud. Because we have case law, when we deal with a case of negligent misrepresentation, that is from the Reinhardt case, the Supreme Court case from 2013. Justice Biles gave the opinion on behalf of this court, where any duty for negligent misrepresentation is confined to those for whose benefit the wrongdoer supplied the information and intended to influence. And again, that would be only Mr. Stroud, the owner of the policy.
Counsel.
Actually, I think
Sorry, go ahead.
the Reinhardt case, I'm not sure goes to that point as well as you are suggesting, in that one of the parties that was not a part of the transaction was the corporation, the LLC. And yet the LLC was allowed to recover in Reinhardt. So doesn't Reinhardt actually show that a third party who wasn't necessarily a part of that, underlying contract itself, be a beneficiary that could recover, and essentially as a third party beneficiary?
Yeah, I think in terms of whether a duty would be owed to Mrs. Stroud or the beneficiary can be just explained by explaining what an impossible conflict of interest that would put the insurance agent to be in. And if I can explain one point that I would like the court to walk away from our oral argument today, and that is that Mr. Gwynn was an agent for Ozark. When we see the briefing and the case law, the briefing from the parties and the case law from the courts as well, when we see the term insurance agent, it's often not clear, is that an insurance broker who's hired by the policyholder or the potential policyholder to go out and canvass the marketplace for 3 or 4 or 5 different insurance products that could be the best fit for the policyholder. That would be a broker whose client is the policyholder. That is not the case of Mr. Gwynn. Mr. Gwynn is an agent for Ozark. He is captive to Ozark. He owes his duty to Ozark, his employer. He is not out there looking for different policies for the policyholder. He's looking only at Ozark policies. That is why his duty to anyone is owed to his own employer. But if a fiduciary duty would apply to a beneficiary, that would put Mr. Gwynn, whether he's the insurance agent or an insurance broker, in an impossible conflict of interest, because the policy owner always has to take in mind the amount of the premium in effect, because they're the person that has to pay it, right? The beneficiary of the policy, they don't really care how much the policy owner has to pay for the premium. What they want is the highest amount of death benefit possible. So the two have competing interests. It naturally follows, if this court would extend a fiduciary duty to the beneficiary, it would naturally follow that it also extends to the policyholder, but the two have competing interests and would put the insurance agent in a conflict of interest. What if the policy owner comes to the agent and says, I want to cancel the policy. I want to reduce the amount of the death benefit, or I want to change the beneficiary. If that's done, that puts the insurance agent in a conflict of interest with what is in the best interest of the beneficiary.
I mean, part of the problem, though, counsel, is that it's really an uncontroverted fact that if Mr. Gwynn had not picked up the phone that Mrs. Stroud would have $60,000 instead of $30,000, right?
There's no indication otherwise that would have changed.
Because
Right.
they weren't motivated to do anything until he motivated them.
Right. Yeah, and the reason that, Your Honor, you had asked about why he called. Mr. Gwynn was new to the area. He was the new agent to the area. So he's familiarizing himself with the different insureds in the Wichita area. And so when he looks at his list, he sees the Strouds are there. He also sees that their policy is going to be changing in 3 years. So in 3 years, Mr. Stroud would not have the right to convert the policy from a term to a whole life. And also his premium would go up.
And that's fine, except then he finds out that Mr. Stroud's about to go under the knife and have very, and have pretty serious surgery. And the idea that you would change horses and reduce the amount of your insurance proceeds really stinks. Right.
So-
I mean,
so-
just
right.
past all the real party and interest and everything else.
Yeah,
It stinks.
Right, and if you read Mr. Gwynn's deposition, as it sounds like you did, you would see that his recommendation was that Mr. Stroud go to a 30,000 term and 30,000 whole life. So it's his testimony that Mr. Stroud didn't take his advice, but wanted to make this decision of having the whole life policy and the benefits that come with the whole life policy, which include the fact that it can't be cancelable. You've got it for the long term. You can build up cash value over time. And that was his decision, even though it was Mr. Gwynn's testimony that he changed that to a 30,000 term and a 30,000 whole life. Nevertheless, that was who would be in a better position to know Mr. Stroud's physical health? Would it be Mr. Gwynn, who shows up just today for the very first time? Or would it be the Strouds? And it was obviously Mr. Stroud's decision to go ahead and change that policy for the benefits of the whole life that it provided. But the fact remains, in terms of whether a fiduciary duty can apply to that situation, the facts are that it's never been extended in a Kansas case to a beneficiary of a life insurance policy.
But if he misled them to think that that those premiums could go up before the end of the 3 years.
Right.
That's what's motivating these people.
There is not an allegation that it was going to go up within the 3 years. The allegation in the pretrial order and in the interrogatory answer is that Mr. Gwynn told them that the premiums were going to increase, and they were going to increase. That was a true statement. They were going to increase in 3 years, but it's not an allegation in the pretrial order allegations in the interrogatory that they were going to go up immediately. I know that is the argument that's made in the briefs and the argument at oral argument, but that was not the allegation. So the fact remains is there was no misstatement that was made by Mr. Gwynn. Everything he said was accurate, and we can accept all those things as true. And the fact remains is it was Mr. Stroud, who again would be in a better position to know his physical health than anyone else, who made that decision.
I thought there was a representation, at least counsel, according to when I asked what was the false representation, and it was the policy could increase at any time.
That is not consistent with the record.
Well, what the Court of Appeals says is that the Strouds were concerned that their premiums could go up while they were down in Houston. And Mr. Gwynn says, well, they can go up a lot. And, so he doesn't just extend the rest of the sentence to make it precise to disabuse them of the concern. I think that's getting to where the heart of the bait and switch is happening.
I understand that. And again, I'm going by what was actually alleged in the pretrial order and in the interrogatories, because of course, that's what the district court relied on in its decision and what the Court of Appeals reviewed. And so then that gets to the fact, let's even assume a misrepresentation has been made. The only person who can make an actionable claim for that is the estate of Mr. Stroud, not Mrs. Stroud herself. And then it gets to the point of she was not the owner of the policy. She didn't have the obligation to pay the premium, didn't have the.
And you're relying on 60-217 for that?
Yes, sorry.
Real
the
party of
real
interest.
party in interest.
Let me ask you a question about that. You read the very first part of subsection A, but the second part lists the people that can sue in their own name without joining the person. Is that a list that is like a list including but not limited to, or is that it?
There aren't any others that are listed there, and I haven't seen any case law, to be honest, justice standards that address that specific question.
But it could be bigger than, I mean, because the federal analog to that is Federal Rule of Civil Procedure 17. And the 1966 Advisory Committee notes contemplate that this is not a list that is discrete and that it's just a list of examples. Would you say that our rule is more narrow than?
I would, Your Honor. Just
what is that based on?
Well, just the statutory construction that the list is. But
the Federal Rule of Civil Procedure also has a list.
Right. And of course, that would be a different list for a different ruling in a different court for a different purpose. So I think in terms of substantive law, I mean, a Federal Rule of Civil Procedure would be different than a Kansas statute.
No, I understand.
Right.
I'm just saying that, in construing it, there's nothing there that says this is the list and it can't, it can't include the wife here, for example. And you're saying she can't be a real party in interest based on the list. And I'm just
Right.
saying, is this, is there anything that would constrain us from saying, well, this is just a list of examples, but in this particular instance, she is a real party in interest under their statute?
I don't think there's any law that indicates this is a list of examples. Going beyond that, let's even assume that it was, and she could be considered. The fact remains is there can be no duty of fiduciary duty by an insurance agent or a
Right.
broker.
I wanted to ask about that also, because are you saying that there can never be a fiduciary duty between an agent and a policyholder?
I'm s-
Ever?
I'm not talking about a broker. I'm talking.
know an agent.
Right,
I'm talking
right.
about an
Yes, and I'm talking about agent.
I know the difference.
Right, yes. And in terms of that, no, there's never been,
So you can, an agent can lie, cheat, steal, whatever, and it doesn't sound in negligent representation,
well,
misrepresentation.
well, certainly if there's been in a certain situation, there's always going to be different examples or situations that could.
So there
find
could be a
something.
fiduciary duty, even though you're saying it's a conflict of interest. There
Right.
could be a fiduciary duty for an agent in some circumstances to the policyholder, while at the same time being an agent of the company.
Yeah, I still don't think there could be in that.
Okay, so
situation.
that is a black line rule for
Right.
you.
That's
And there can never be a fiduciary duty to a policyholder
not
during a sale.
right, during, right.
Oh,
And that,
But doesn't the company owns a fiduciary duty, right?
yes,
And the agent acts on behalf of the company.
yes, that would be
I
true.
mean, I understand your point is the agent owes a loyalty to the company, but the agent is an agent of the company, which owes a fiduciary obligation to the policyholder.
To the policyholder as
That was
opposed.
exactly what the
That's
question.
what I'm
Okay,
asking.
okay, I'm sorry. I thought we were talking about back to the beneficiary then. So
No,
sorry for my.
policyholder. No.
Sorry for my confusion. Sorry for my confusion.
And doesn't the panel's decision simply unwind what has typically been articulated as that duty to exercise, just like an attorney or a physician, to exercise that professional care? That has historically been how that legal or fiduciary duty has been articulated all the way back by our court in 1915. And I read the panel's decision of saying that, no, that's not the case anymore, that there is no such duty.
Right, well, sir, I mean, the Spencer case, obviously from this court in 1980, talked about the insured and insured in a first party relationship have an adversarial relationship. They don't have a fiduciary relationship. That was a different context from this case, but I think it's still somewhat applicable to this case and provides the support for that.
So you would agree then that that there is no professional standard of care that an insurance agent owes to a potential customer when procuring insurance?
That's right. That's right.
And that does unwind our precedent.
Well, in terms of the case law that I've seen and cited, I don't believe it does. And I think,
That case law is all from the Court of Appeals. Would you agree?
well, the Spencer case is not. The Kansas,
That's a first party
That's
dispute.
distinguishable.
It's
Right. Right, which would be the situation we're dealing with here between Ozark and Mr. Gwynn.
It was a simple coverage dispute. It wasn't about the duty of an agent when interfacing with the customer to procure the insurance from the outset.
True, true. But I think that I think it can certainly apply by analogy, and certainly that's our position here.
And in terms of the relationship with the beneficiary, your argument about the conflict of interest, how do you distinguish Pizzell versus Zessman, where this court applied a equitable theory so that an attorney was liable to beneficiaries of a trust? And in doing so, they applied a 4-factor test, and recognizing that the argument was the attorney might have a conflict of interest if you created this obligation for the attorney to the beneficiary with whom he had no privity. What distinguishes that kind of conflict of interest from the conflict you're suggesting arises from an insurance proceed?
I think for just one reason, Your Honor, would be the case law from Kansas certainly holds that a duty to give advice must be expressed in contract. There has to be something written down to be able to confirm what that duty is. Typically, if not always, that's what an attorney has with a client. It's undisputed in this case that there was no contract or agreement between Mr. Gwynn or the Strouds regarding his alleged agency there. So that would be one difference. And certainly the difference of a professional as an attorney would be different than an insurance agent, again, who owes his allegiance to Ozark, as opposed to an attorney who's actually retained by the client, who's actually retained and acting on that person's best interest. It's closer to a bank debtor-creditor relationship that an insurance company has than as opposed to a banking relation, or as opposed to an attorney-client relationship.
But Gwen personally received a financial benefit from the transaction.
He would have received a commission, yes. So, but in terms of the relationship or a contract, there would not have been one.
What was the contract in Pizzell versus Zessman?
Your Honor, I could not tell you that. I'm not familiar
Maybe-
enough with that case to be able to tell.
Yeah, I don't think there was a contract. It was trust beneficiaries sued the uncle's attorney after the uncle died and the land went to the other family.
If the attorney there, then I assume that there was, again, a relationship between the attorney and the client. And it would be, and again, this would be a situation in our case where Mr. Gwynn would not have had a duty to Mrs. Stroud, but would have had, and as a result, not been a fiduciary there.
I'm not sure if that's what that case stands for, but I appreciate your answer.
Are there other questions?
Just one real quick
Sure.
final question for me. Let's assume that we do think that there's still the duty of professional care still exists. Then to the point that you've already made, then there's a separate question about, well, we're talking about a beneficiary here, not the policyholder. And then I'm sure you're familiar, because it's in your briefing, the Pitts decision from the Iowa
Right.
Supreme Court. Can I hear your argument as to why this court should, or I assume should not, from your perspective, embrace that same rationale as the Iowa Supreme Court to extend that duty to beneficiaries
Sure.
in limited factual circumstances?
Right. Certainly, the Pitts decision is a minority view. It's a minority view, and we've cited cases in the footnotes, certainly in our Court of Appeals brief, that shows the majority rule is that there isn't a fiduciary duty in that context. And second, I'd also respectfully say that if that's going to be changed, that would be the province of the legislature to make that substantive change to the law as opposed to this court.
Any other questions? Thank you.
Absent any other questions, thank you for the opportunity, and thank you for everyone coming out. It's really overwhelming and nice to see so much interest in the court. Thank you.
Mr. Wilson, you reserve 2 minutes.
Counsel, if I may, I'm just going to jump in with my question. Why wasn't this prosecuted on behalf of the estate?
Because the damages belonged to Mrs. Gwynn, the plaintiff.
So it was a strategic decision, essentially.
Well, what we're doing here is getting into the real party and interest.
Yeah, that's my question. Why,
Yeah.
why wasn't this brought as a claim on behalf of the estate? Then you avoid everything we've been talking about.
We also dilute and run the risk of diluting Mrs. Stroud's recovery.
How is that?
In this case? Well, you open an estate, it's subject to the claims of creditors, subject to administration costs, subject to Mr. Gwynn's estate plan if he didn't have one, goes by intestate succession, all kinds of things. And
But the asset's not part of it's not part of the estate, right?
I beg your pardon?
The insurance policy designating the beneficiary isn't part of, it's not an estate asset.
Well, that
is it?
gets into the Pitt case, which we are urging this court to follow, which we are urging. The Pitt case recognized the rationale of Pizell. It didn't specifically address the Pizell case, but it adopted the California multi-point test. And so when we get into real party and interest, we are urging this court to follow the logic of the Pitt case, which is very close to the facts of this case, where you had an insured and an insurance agent and a beneficiary. And also to follow the logic of the Pizell and apply that to the facts of this case. But the whole distinguishing thing here is that defendant Gwynn was not addressing a potential client. He was addressing a policyholder. And when he did that, when he came in and said, we need to talk about your insurance policy, that switched from, I'm trying to sell you an insurance policy and an adversarial position, which is what the Spencer court was looking at, to one of an advisory position. And that changes the whole complex of what's going on here. It puts him in the position of a fiduciary to these people when he comes in and says, trust me, here's what we need to do. So it changes the whole complexion. And let's see, Pitt case. I don't understand 6 alleged misrepresentations. There was one. He said, if those premiums go up when you're in Houston, you could lose your policy. And he knew they couldn't go up while he was in Houston. There had been a lot of facts brought in and in the briefing too, and we addressed that in our brief.
Is there an uncontroverted fact? I'm sorry, I don't remember that he did know it was upcoming in August, or was that date somewhat nebulous in?
Well, I'm not quite sure when the surgery was. It was between that visit and August when Mr. Stroud passed away.
But did he know that? Or did he simply understand? I know at some point the surgery was going to happen after he had recovered sufficiently from the stroke. So my question is there an uncontroverted fact that addresses specifically that he understood that surgery was imminent
Yes,
in
ma'am.
less than
Yes.
a few months,
Yes.
for example?
Uncontroverted facts are that this surgery was the foremost thing on the minds of the Strouds. It's all they talked about. And that they told him about the surgery and all about it. It's about what all they talked about when Mr. Gwynn was at their house. And that surgery could be next week, next month. They just didn't know it could be any time. So it was imminent, certainly not without the 3-year period.
Any other questions?
Well, one thing, what I was going to say is there've been a lot of facts brought in on this case in the briefing and an oral argument by counsel that are not in the uncontroverted facts. And I would just ask this court once again, please take the uncontroverted facts of this case and just apply them in this case and apply them to the theories that we are presenting. And like I say, I think we hit every base. There are some other things I wanted to address, but I'm getting tired, so anyway, thank you.
Thank you. Thank you to both counsel for your arguments in this matter tonight. We will take this case under advisement. I will now call case number 123559, State of Kansas versus Frank Raymond Crudo. I'd remind counsel to again, please state your appearances. So we have that on the recording. Thank you.
May it please the court, Peter Meharry for Frank Crudo. And in this case, Mr. Crudo was convicted of possession of marijuana with intent to distribute, misdemeanor possession of marijuana, and then also failure to have a drug stamp for his marijuana. This case arose out of a traffic stop on I-70 in 2014. We've gone through 2 trials and now we're on our 2nd appeal in this case. Kind of the main issues and the ones that I'll touch on, unless the court wants to go elsewhere, are the search of the camper and whether or not that was proper. Then also whether or not the testimony of Officer, I believe it's Rickard, was expert testimony, which would have required pre-trial disclosures. As I said, this arose out of a stop on I-70. Officers with Geary County saw my client driving a pickup, towing a 5th-wheel camper, heading eastbound, and did not feel that his license plate was properly illuminated. So they initiated a traffic stop. And the uncontroverted facts are, as the officers walked up to the pickup, when my client rolled down the windows, they smelled marijuana. From there, the officers searched the pickup and they found a small amount of marijuana, kind of as I understood it, on the center console in the pickup. They didn't stop with the pickup. They then searched the camper as well and found more marijuana, which led to the distribution charge. It's our position that the search of the camper was improper under the 4th Amendment and certainly under the 15th, Section 15 of the Kansas Bill of Rights. There was no indication of any criminal activity in the camper. The officers were clear that they had walked by the camper before they got to the pickup and not smell anything. They only smelled the odor of marijuana when they got to the pickup and my client rolled down the window.
Would your position be any different if your client rolled down the window and they smelled marijuana and they searched the pickup truck and found 19 pounds of marijuana? Could they then, would there be probable cause to search camper then?
I don't believe so because they testified they didn't smell anything when they went by the camper. There is no indication, and I don't think you can just automatically make the leap, well, there is drugs here, so there are drugs there. One of the things about the 4th Amendment is you're supposed to have a nexus between the suspicion of criminal activity and the place to be searched. Here, the officers testified they had no suspicion of criminal activity in the camper. They found a small amount of marijuana in the pickup, but I don't think that translates to say, okay, just keep searching and see what you can find. I think the search became overbroad and just a general search of my client's camper without any suspicion of criminal activity.
So it doesn't make any difference that the camper was hooked up to the pickup truck. And so they moved in one, I mean, they weren't separate vehicles. The camper was not stationary. That doesn't make a difference.
We don't believe it does, Your Honor. We believe that there has to be probable cause with regard to the place to be searched. And here, there had to be probable cause with regard to the camper if they wanted to search the camper. and that was absent in this case.
If the pickup truck had a bed on it, okay, let's say it wasn't a pickup truck, let's say it was a car with a trunk, and they found 19 pounds of marijuana in the back seat of the car, could they search the trunk?
I think case law in this, from this court as well as other courts say that yes, in that instance you can.
What's
If-
the difference?
I think the difference is the camper is a separate entity from the car. When you have a car and you have probable cause that there's criminal activity going on, courts, not only this court, but courts all over the place, say you can search anywhere in the car,
Why is that? Because there's exigent circumstances,
correct?
because the car can be moved.
There is exigent circumstances provided because the car can be moved,
But
but
the
there's
camper could
also,
be moved too.
there are also probable cause. And that's the missing link here. There's probable cause that there's criminal activity in that car.
Why wouldn't there be probable cause to believe that there's criminal activity in the camper?
Because the officers testified, they didn't believe anything was going on with the camper. They testified, as I said, they walked by, they didn't smell anything. They testified, we didn't have any indication that there's criminal
And
activity.
why did they want to? That's the uncontroverted testimony. They said, we wanted to search the camper, but we didn't believe anything illegal was going on in there.
Their testimony was that they did not believe there was any criminal activity going on in the camper.
Wasn't that before they found the marijuana in the truck?
That was the testimony, Your Honor, that they said they smelled marijuana from the pickup. At that
So
point, they,
probable cause can develop as a search is ongoing.
it can, but in this case, all they found was a small amount of marijuana.
I'm just suggesting that that testimony doesn't actually answer, I think, Justice Standards' question, which is why wouldn't, after the finding of the marijuana, why wouldn't there be probable cause to search the rest, all compartments in the vehicle, considered broadly to include the camper?
There's going to be, under case law, probable cause to search all compartments of the vehicle. But I think you have to look at the camper and whatever's towing it separately.
What if it's not a fifth wheel, but it's an RV that has 5 bedrooms 40 feet behind me?
Sure. In that case, and that's the Carney case, is that the US Supreme Court says you can search the entire vehicle.
And so what, yeah, again, it's the same question. Conceptually, it's difficult to understand why the probable cause analysis would be different between the 40-foot long RV versus the fifth wheel camper.
Because the 40-foot long RV is one unit.
So you're relying
We have-
on the physical connection that a person could traverse without sort of getting out of the truck and going into the camper door.
I think a camper is a separate unit and it has to be viewed separately than the car or pickup or whatever is towing it.
What if it had been a flatbed trailer with a tarp over the 19 pounds of marijuana?
I think, they probably would have maybe seen it, but again, when
No,
you
there's
have,
a tarp over it, so he can't, it's not plain view.
if it's not
just a
plain
trailer.
view, I think they have to have probable cause for whatever vehicle or entity they want to search.
So it doesn't matter that it's an RV or that it's someplace you could possibly live. If
No, I think if they had been towing a boat, I think the same rule would apply. You have to have probable cause that that boat is hiding some drugs or there's criminal
So,
activity with.
so
regards
you
to
have
the
a
boat.
black line at the trailer hitch.
That's the line I want to draw.
Gotcha.
Well, I don't actually think you are drawing a line. No one disagrees that you have to have probable cause to do the search. The question is, isn't it an arbitrary distinction to say, oh, you do have probable cause to search the trailer, the flatbed, or you do have probable cause to search the RV, but for some reason you don't have probable cause to search the RV, search the fifth wheel or the boat?
I would say you can't search the flatbed either, Your Honor. I believe that when you have two units, a car, pickup, whatever, and it is towing something, a separate trailer.
Can you
boat,
articulate why that probable cause analysis is different? What is it about the separate unit that changes the level of suspicion about criminal activity?
I don't think it necessarily changes the level of suspicion.
Well, that's what
What-
probable cause is. That's what we're talking about, right?
But what I'm saying is you have to have probable cause for the area you want to search. And when you have two things, when you have a pickup, when you have a camper, probable cause for one does not give probable cause for the other because they are two independent, separate things. You need to have specific probable cause for that trailer if you want to search that trailer. Whether or not it's a trailer, boat, camper, what have you. And we believe that the Fourth Amendment provides that protection. And here we think it's particularly terrible because this is a camper and it is the personal private space of my client. And the officers in this case, I'll move on in 2 seconds, but I want to leave the court with this on this issue. And that is that the officers searched the private space of my client without a warrant and without suspicion of criminal activity. And we believe that the Fourth Amendment steps in and provides protections for my client in those situations. I'd like to touch base a couple things with regard to Officer Rickard as an expert. And in this case, he testified about the drug trade. He testified about packaging that would be indicative of intent to distribute. And he talked about wholesale pricing. We believe that that is far beyond just something a layperson would know.
Can you suggest where we would draw that line between what is kind of the specific knowledge that's particular to a professional witness or a law enforcement type witness that has experience and training versus common knowledge, and where it's a pretty blurry line. I think you would agree with that, but do you have some advice for us as where we would draw it? I understand your argument. I mean, in this case, the particularized scent, the smell was raw marijuana. They didn't find any raw marijuana in the truck.
Right.
And in fact, it was emanating as soon as he rolled down the window, it was raw marijuana as opposed to any other kind of marijuana, which has a specific smell, I guess. But wrong there. But what about just the particularized knowledge that you specified, how it's packaged, where it comes from? Some of that can be common knowledge, but some of it isn't. Where would you draw the line?
I'll freely admit it's probably going to be a blurry line and it probably one of those that is going to be somewhat case by case basis. But I think kind of the baseline you start with is what would a lay juror know? Would a lay juror know what the price of marijuana in California is versus what the price is in North Carolina?
Well, how do you separate that? Wouldn't a lay juror know that 19 pounds of marijuana specifically packaged and even identified by a particular type of marijuana could imply or is for distribution as opposed to personal use? Wouldn't that be a kind of a common, would that take an expert to testify to that?
I think it would. As far as the specific packaging, I don't think most people, some people may know, but most people don't know how marijuana is packaged. They don't know how it's packaged for personal use. They don't know how it's packaged for distribution. I think that goes beyond what you could expect a lay juror to know.
Do most
Does it-
people know how much 19 pounds is?
I don't know. And I would argue certainly marijuana.
You would need an expert to talk about 19 pounds, what 19 pounds is?
I think marijuana is a different cat than some of the other drugs, as far as quantities, Your Honor. Amounts of marijuana is, you have to have more for the same kick as other drugs, so to speak. So just because it's 19 pounds, I don't think that automatically would tip a jury to say that's clearly distribution.
And who should make that judgment of what that jury that's sitting in that courtroom? I guess this is a good point to ask as a reminder what our standard of review is.
We believe that this is on experts, I think it's a mixed question. Whether or not a person is an expert under the statute, I think is a question of law for this court. Whether or not they're qualified, I think probably delves into abuse of discretion. But it's a district court's judgment and determination at the outset. This is expert testimony.
So you think we're in a better position than the trial court to decide what the jurors would understand given the evidence? Where that line would be between what they can understand without the assistance of an expert and when they need an expert.
I think this court would be in about the same position because you're looking at just the common knowledge layperson standard. I don't think that necessarily is jury specific such that Cloud County is one standard, whereas Shawnee County is another. I think you're having that kind of baseline standard of what's common knowledge, what a lay juror would understand. And from there, this court can say, I don't think they would understand this. I don't think they would know how drugs are moved, how they're packaged, what the pricing is. That is beyond a layperson in our view.
I want to go back to that standard of review real quick. So for the district court determining whether or not this is under the statute, when you read the statute, whether it's going to be expert testimony or lay testimony, is that decision, how is that decision reviewed by us? Is that abuse of discretion?
I think whether or not the person is an expert is a question of law. Whether or not they fall under the statute requires interpretation of that statute and again, is a question of law for this.
Well, no, I'm more talking about, I mean, there are certain rules if someone, not whether or not they're an expert in that area, but in other words, is the testimony under, is the expert testimony going to, specialized knowledge, scientific, technical, or specialized knowledge? That decision saying, the judge saying, that's not scientific, technical, or specialized, so I'm going to let you testify as a lay person. What is our standard of review for that decision by the district court?
I think that's a question of law because you're determining whether or not that witness falls under that statute. And I think that involves interpretation of that statute, which are questions of law for this court. Whether or not at the start, if he is an expert, I think is a question of law for you to determine whether or not 6456 he falls within that statute.
So if it is an error of law, is it subject to a harmlessness test?
Yeah, we have argued that it is subject to harmless error analysis. And here you can't say it's harmless because of the importance of this testimony towards the charge of distribution. That was the major charge in this case. The first trial hung on the issue of distribution. State retried my client on the issue of distribution. That was key in this case. And his testimony, his expert testimony, was key for the state to make their case.
Does it make any difference that he was testifying as a fact witness
Yeah.
versus someone who's brought in after the fact to review documents and give an expert opinion?
I will disagree a little bit that he was testifying as a fact witness solely. He certainly was testifying to the stop and what he saw, what he observed. But then when he's talking about the marijuana trade, he's not testifying to his perceptions about the marijuana trade based on the stop that night. He is testifying based on his training and experience that have nothing to do with this case. That's prior training that he's gone through with various law enforcement academies. So in that regard, he is giving an opinion on the drug trade, and that is not just a fact witness.
So it's the fact that the testimony exceeded the scope of the facts of the case that he was, from your perspective, he's talking more broadly about things that are outside the scope of what happened in this case.
I think that's correct. He's testifying beyond his perceptions of the stop.
How did the, I should know this so I apologize, but how did the evidence from the first trial differ from the second trial? So this 19 pounds of marijuana, did the officer give the same testimony about distribution and pricing and the things that you think require an expert testimony?
I think it was pretty similar, Your Honor. I don't think it was, I think probably not identical or anything, but I think it was along the same lines. I'd have to go back and check.
And it goes to the harmless error calculus, if you will, that, if the state tried to bolster its case on distribution because that's where they hung, and this was the way they did it, then the admission of this testimony might look a little more harmful than it was the same testimony and this group just believed the evidence as a whole as opposed to the first trial?
I think, again, I think it was along the same lines as far as what he testified between the trials. But I still think it is problematic because it was the only issue in the second trial. And this was the key evidence against my client as to the distribution charge. If there are no other questions, we would ask this court to reverse this manner for the reasons that we've cited in our briefs. Thank you.
Thank you, Mr. Harry. Mr. Cruz?
May it please the court, Tony Cruz on behalf of the state of Kansas. As this court has already pointed out, it's very difficult to kind of ascertain where this court is supposed to draw that magical line of when officers have probable cause to search a vehicle and the containers.
Mr. Cruz, could you maybe adjust your microphone and see if we can pick you up a little better?
Sorry, they're doing a lot of control burns and I'm breathing a lot of that smoke in, so I'm a bit raspy.
I think we all understand, but I think I can hear you better, so thank you.
Okay, I apologize. No, and what this boils down to is whether or not, or if this court's willing to basically forego the Carroll doctrine. Because as we all know, the Carroll doctrine says once you have probable cause to search a vehicle, you can search all of the containers which may contain that contraband. In this particular case.
Isn't, or at least I'll articulate my understanding of that rule. The reason for that rule isn't because we just want to sort of draw arbitrary lines. The reason for the rule is that the belief, the view that once you have probable cause to search part of a vehicle, you actually have probable cause to search the entire thing, because it makes the level of suspicion has crossed that threshold to where law enforcement has that reasonable belief that there could be criminal activity in any part of what's sitting on the wheels.
Right.
Would you agree with that?
Yes, yes.
But if it was a cell phone inside the vehicle, obviously they wouldn't have been able to search that without a warrant under the same doctrine. Would you agree with that?
Correct, because we have a separate set of laws for cell phones.
And I guess it is, what is it that distinguishes an item like that, from the Carroll doctrine itself, where you could search containers? The fact that it can't store other incriminating evidence itself, or is it because there's a higher expectation of privacy on some items that might be found within a larger container?
For cell phones, we have a very specific case law dealing with the U.S. Supreme Court that have said that cell phones and now that we're talking about smartphones contain a lot more that information, personal information, than just simply what they used to be able to do. It used to be you had a cell phone, you could make phone calls. Now they've got pictures on them that they can access the internet, the emails, texts. And so there's a lot more personal that information that's involved with.
Because there's a
having cell
higher
phones.
expectation of privacy.
Yes, and then that's why if in this case they had found a cell phone, they would have been required to have obtained a search warrant to get into that cell phone.
And if the fifth wheel or pop-up was the person's primary residence, would there be an argument, at least the same rationale, that there was a higher expectation of privacy?
I believe the case law says that it depends on how that fifth wheel happened to be found. If in this particular case that it was mobile because it was still attached to the truck and moving on I-70, there is not that expectation of privacy because it would be the same as having an RV. If that fifth wheel had been in an RV park where it been detached and you had water lines hooked up to it and power lines to it, I believe then that would be different because at that point, it's not inherently mobile. The thing's actually attached and it's being used as a residence.
Don't these things go to exigent circumstances, not to probable cause?
To search it without a warrant, yes.
Right. In other words, the distinguishing things that you're describing, the factual circumstances, don't actually go to the probable cause analysis. They go to other parts of the analysis.
Yes, sir.
So yeah, I guess I just don't understand the idea that differing levels of expected privacy would change the probable cause analysis. Do you think that it does?
And it would to a certain extent, and the specific example was that the cell phones. And there was a plethora of case law, not only for this court, but also the US Supreme Court, saying that even if you were to find a cell phone during a traffic stop, you can't search it. Even if you find contraband in that vehicle, you can't search that phone unless you have a search warrant. So that's an expectation of privacy. You still have
Can you
still
seize it?
probable cause. You can seize it. You just can't search it.
What if they would have found a gun? I don't know, with the serial numbers filed off. Could they search where the car lighter is? You know, the whole line of cases that when at least when you have a warrant and your particular warrant is when you're looking for something and you can't look in a place where obviously what you're looking for wouldn't fit.
Okay, so in your honor's example, are you saying that they smelled the odor of marijuana and that caused them to search the vehicle and they found a gun?
I guess it's not a very good example.
Yeah, see, I'm just trying to make sure I have the facts straight, so.
Well, no, but they didn't smell the odor of marijuana. I'm not sure, the gun was in plain view.
Okay.
And so they were looking for other guns. Can they look in crevices that wouldn't hold a gun or containers?
I don't think they'd be able to look in areas where what I would call firearm paraphernalia couldn't be found. For example, when you're talking about a firearm, you're not just talking about a gun, you're also talking about bullets, and you're talking about potentially magazines or a gun case, a gun kit, a gun cleaning kit. So if you find a firearm that you believe is contraband, I think you're allowed to search in areas that in the vehicle that you could find contraband associated with that firearm, to include bullets. But again, depending on the circumstances, it may be a better idea to just obtain a search warrant, just so you're covered.
If you assume we accept your argument that the pickup and the trailer, the fifth wheel, is all one unit and probable cause for one is probable cause for all, give me your best argument why that the conviction for simple possession is not a lesser included of possession with intent to distribute.
Okay, so during the first jury trial, we presented evidence only as to the bud of marijuana that was found inside the truck, and also the 19 bags of marijuana that was found beneath the shower that was inside the trailer. And that was, we were going to stick with that evidence because the other marijuana that was located beneath the stairs that also had a grinder, some rolling papers, that was not tested by the KBI. So we were not going to allege personal possession of that alleged marijuana because again, we had no scientific testing for that. It was defense counsel, apologize. That it was defense counsel that introduced the bag of marijuana that was beneath the stairs. And that's what the jury found him guilty of that marijuana. In the second case, and they also found him guilty of no drug tax stamp. The only evidence pertaining to a no drug tax stamp pertained to the 19 bags of marijuana. The jury hung on the possession of marijuana with the intent to sell charge. And that's what the second trial was on. On that one, the only evidence was the 19 bags of marijuana that the defense still alleged that was, was still possessed for personal use. So I think that the fact that you had personal marijuana alleged to have been found in one part of the vehicle, and then you had a separate 19 bags of marijuana that the officer said that was for distribution. I think that's the difference.
So could you have charged 19 separate counts of possession with intent to distribute? Because
No,
19 bags?
no.
Because you're a benevolent prosecutor or because as a matter of law, you cannot?
As a matter of law, because this would be, for example, we do have case law that says, like, for example, if we were to do that a search warrant on a person's house and we found methamphetamine just for personal use, but he found it in the living room, in the bathroom, in the bedroom, in the kitchen, that in their car, that on their person. The state, as a prosecutor, I would only charge that as one count because the allegation is, in my perspective, that they're alleged to have possessed all of the meth. However, it's still, it doesn't change the dynamics of its, for the intent to sell or if it's for personal use. So it'd be on one count. And then you get into the whole multiple acts, that analysis. And again, I think if you find that type of drugs throughout a large area, that this court would not uphold the 19 count because again, it's just one incident.
Before, oh, no, go ahead.
Well, I was going to move him over to.
That's what I was.
Okay.
Gonna do. So you can go ahead and
So
I'll follow up maybe.
Move you over to the expert witness question. And just ask at the outset, do you as a prosecutor or in your knowledge of how cases are typically prosecuted, does the state certify other expert witnesses? And I'm thinking of coroners who testify about cause of death, the KBI lab techs who testify about drug identification, or perhaps who do the DNA analysis.
Yes,
Does the state certify those people as experts?
yes.
So why wouldn't you go through that process when you have a law enforcement officer who's testifying outside the scope of the actual facts of the case about things like the drug trade in California? In other words, I mean, you do it with other experts who are necessary to your case. Why not do it for the law enforcement?
Because those other witnesses, when you're talking about doctors and you're talking about forensic chemists, they have a very specialized skill set that's all that they do. So they have extensive education, they have extensive training, and that's all that they do. And so because, for example, if you're going to call a doctor that in a homicide case, more likely that you would have them testify as to the cause of death. Well, they're the ones who have, that training and that experience to be able to ascertain that the victim died that either at a certain time or a certain manner.
How is that different from a law enforcement officer who has specific training and experience in a small area of human knowledge?
Because what they're testifying to, in my opinion, that's not so scientific or complex or technical that they would qualify as an expert.
What if this law enforcement officer had a stellar career as a physician before becoming a police officer? Would they be able to testify about cause of death? I mean, I would assume the answer is no, without being certified as an expert. So you're trying to draw a distinction between the knowledge base.
And again, generally speaking, when you call those types of experts to testify, they're talking about things that are so foreign that you really need somebody to basically walk a jury through every aspect of their testimony. Where when we're talking about drugs and the drug trade, you're not going to that level of the explanation.
So this is common knowledge to the 10th power.
This is common knowledge for officers, I think, in general.
Well, that is what lurks behind all my questions, which is it strikes me that the state wants a general rule that law enforcement officers are exempt from the expert witness statutes. But in the course of our short conversation here, it strikes me that you've just said that they're not essentially. So why wouldn't we just apply the typical, is this outside the ordinary understanding, common knowledge of a juror? Why wouldn't we just apply that to every subject that an officer is going to testify?
To the flip side of that, that would mean that that the state would have to certify an officer if they have any sort of specialized training. So for example, if they're running a radar gun, because that's specialized training, then I would have to certify them as an expert, even though most officers will tell you, I was trained to turn it on and I do the calibration. How the physics of how the radar gun works, I have no idea, don't want to know, because that's just not what I do. And so for me, having to certify an officer for every aspect of their possible testimony on things that they see every single day.
It's not every aspect of their possible testimonies when you're trying to utilize their expertise in a specific area to gain a conviction on a specific element of a crime. Here, it's the intent to distribute, and you're trying to, in a way, bootstrap some of the common experiences, but really the specific knowledge they have about the drug trade that isn't common, ordinary knowledge. And along with Justice Stiegel's questions, what's the problem with saying, in this particular case, this officer is going to testify about the drug trade, his knowledge and his training and his experience or her experience with the drug trade, and disclose that pre-trial. I don't see these are serious cases, results in serious deprivation of liberty. It's not just a common possession case. This is a 10 to 15 year sentence this person is facing. And what's wrong with the state clearing that hurdle to deprive that person of his liberty for 15 years?
As far as having them declared an expert, that wasn't done. But this wasn't a case where the defense was blindsided by the officer's testimony. He testified at prelim. He testified, I believe, twice during two different suppression motions. They had copies of his affidavit. And so
I'm not talking about surprise. It's just that what the evidence is that's provided by the officer, I think is in some of this, in what is offered, is beyond the common knowledge of a juror, of these people out in the audience. It just is. And so I guess I'm asking you, what is the problem, as Justice Stiegel asked, with designating or specifying this particular state's witness is going to testify about this?
I think that would boil down to honestly, the facts of each case and honestly, how much experience an officer has, because in the one hand, real easy to certify an officer who has a 15-year career and has a lot of specialized training, as opposed to a new officer who has not as much training, but has the exact same facts. Be real easy to certify one, probably not going to be able to certify the other one. And then we're stuck in the same boat because you've got the defendant in two cases that did the exact same thing, though, because one officer is brand new, doesn't have all of the extensive training, they're not going to be able to be certified as an expert.
Isn't that case in point? That and someone without the training experience, they're going to testify to this anyway, but they don't have the training and experience to do that?
As an expert, I don't think that they would be certified by the court to be able to testify about that. And if they're, and again, if we have to go through a docket hearing to determine whether or not that they're an expert or not. If the court deems them not to be an expert, they're not going to be able to testify even.
But you can bring the veteran in to testify.
Assuming
Because
that
yeah, whether however many pounds, 19 pounds is distribution, whether the drug trade goes from west to east, whether people want to drive faster because they don't want to be in the road as long. I mean, those are things that you could just have another be qualified as an expert to testify.
If you're
Another-
operating in a bigger jurisdiction, it'd be quite a bit easier. But I'm also thinking about smaller jurisdictions that don't have that resource available.
Why isn't it enough for the officer to just say 19 individual 1-pound bags all wrapped up the way they were found is, a ridiculous amount of personal use? Doesn't that get you all the evidence you need on the intent to distribute?
Not according to State v. Smith, no. Because State v. Smith was a case where
Well, you get an
Yes.
inference. I mean, we've been round and round on that. And the pick instruction tells them they get an inference.
but this court's also held that pick instruction is not accurate.
Right.
So we
Right.
can't use it anymore.
Let's not start on that,
Right.
please. But I am serious about, and I guess I don't appreciate, what is it you think you need to establish this intent to distribute beyond kind of the obvious facts of what the officer saw?
Oftentimes, in dealing with certain cases, we have to explain the conduct of the officer and also explain why they did certain things, and also why in this particular case arrested somebody for possession with intent. And so everything that they've known based on that their training experience goes into that. When you present it to a jury, you tell a jury that's 19 pounds. Juries don't. It's like, okay, was that a lot? That a little, small amount? And so we have to explain to them what 19 pounds really means.
Other questions?
Thank you.
Mr. Green.
Just a couple comments that I'd like to make on the issues with regard to the expert. I think it is important to note, I think the state wants to have it both ways. They want to have an officer get up there and testify as an expert, but without having to disclose them. And one of the reasons why we have the disclosure statute is so the defense can question those expert opinions. The disclosure requires information as a written report, witness qualification, and witness opinions. They don't want to give that up. They don't want the defense to be able to go out and get an expert and say, look at this, what they're saying. What do you think? But they want to put that into trial. And here, then they paint him as an expert. The state questioned Officer Rickard about his qualifications, about how many hours he had in drug interdiction training. So they want to be able to bring him out as an expert, but not follow the statute. He was an expert in this case, and it required pretrial disclosure. And I think it's pretty clear that he was an expert, because if the defense had put anybody on the stand to say the exact same thing, the district court would not have allowed it. They would have said, this is expert testimony, no disclosure, no witness. So we believe that was an error on part of the district court, and it did matter in this case because distribution was the main charge. It was all that the second trial was about, and this was the best evidence the state had on that issue of distribution. So for those reasons, we would ask this court to reverse this matter for the reasons we stated today and in all the briefing. Thank you.
Thank you, Mr. Meharry, and thank you, Mr. Cruz, for your arguments in this case. The court will now take this appeal under advisement. What I mean by that is that the next step is that the court will meet and will discuss the two cases that we have heard this evening. In those meetings, we'll make some preliminary decisions about what we as a group of 7 believe the outcome should be. One justice will take the lead in writing a decision that will be circulated to the others. I often compare this to thinking of your biggest nightmare of your English teacher with the red pen, because that's what we'll do to each other's work product with this as we edit and criticize and try to make it better. We will sometimes disagree with each other, in which case there could be multiple opinions that are written. Our final decision is in written form. This sets us apart from other branches of the government, where the legislature doesn't usually explain to you why they voted the way they did, or the governor doesn't usually have to explain reasons behind executive actions. But courts do make specific findings and lay out the reasonings for reaching their decision to help you understand and to help other judges who have to apply our cases understand why we did what we did. When we get to that point when we have a finalized written decision that all of us have agreed on, it takes several weeks for us to accomplish that. Usually 6 to 8 weeks is a fairly common time for that. We file our decisions on Friday mornings. They will be, when filed, they show up on our kscourts.org website. You can find all new decisions and all decisions for a long period of time on that website. So if you hear about any decision, you can find it, and it usually will link to the video of the oral arguments. And so you can go back and watch past oral arguments on decisions that you hear about. We also will have a press release when we issue the decision. So you will have some notice that that decision is out there and that it is posted for your reading. So once again, we thank you for coming tonight. We hope you will be leaving with a better understanding of how an appellate court works and what our function is. We invite you to the reception that will be held in the gymnasium. The justices are looking forward to greeting with you and visiting with you, answering questions to the extent we can. We probably can't get too deep into the cases we have heard tonight, but we can certainly answer some general questions for you. So we'll look forward to that. And with that, court is now adjourned.
All rise.